Consideration. Something in return is to be required to make a valid contract. What is consideration? Section 2, subclause D of the Indian Contract Act defines consideration as when, at the desire of the promisor, the promise any other person has done, abstains from doing, or does, abstains from doing, or promise to do, or abstain from doing something. Such act, abstinence, or promise is called consideration for that particular promise. So, for example, A wants to sell his watch to B for rupees 2000, and B agrees and pay him rupees 2000, and the watch is sold. So, this rupees 2000 is what? This is something in return of that particular watch. This 2000 is the consideration in return. So there are some legal requirements. First one is the consideration must move at the desire of the promisor. This particular consideration should be at the desire of the promisor, no one else. So who has the right to desire the amount? It should be on the desire of the promisor. The consideration may move from the promisee to any other person. Now the consideration may move from the promisee to some other person. The consideration may be an act, abstinence, or forbearance, or a return promise. You can also consider consideration as some kind of act, abstinence, or forbearance, or a return promise. Consideration need not to be adequate. Now the adequacy of consideration, like if some case went to in a court that the table was sold for rupees 500. No. Now, how can court justify what was the quality of the table? 500 was just amount or not? So this consideration was adequate or not, it depends on the promisor. No one else. And no one has a right to question over him. Next is consideration should not be illusionary, but it should be real. This consideration should be legal monetary currency which is followed in that particular territory when you are doing the contract. So it should be a valid consideration as such. Like you can't do like, okay, I'll give you my watch, you give me 2 kg of rice. This is not done. Consideration should not be something which the promisor is already bound to do. Like, if a public servant is bound to do his duty, isn't it? So you can't, means you're paying something to the public servant. You're paying 2 kg of mangoes to the public servant. And in return, the public servant will do the duty. This is not consideration. Because he's supposed to do his duty already by law, isn't it? Consideration must be not be illegal, immoral, or against the public policy. As per section 23 of Indian Contract Act, consideration must not be illegal. Means it should be legitimate thing which is declared legal by law. It should not be immoral in nature. It should not be against the public policy. Next, there are some kinds of consideration: past, present, or future consideration assets. So what is past consideration? If the consideration by a party to an agreement was given in the past, means पहले past में वो consideration दी गई थी before the date of promise, it is called past consideration. For example, A renders some service to B at the latest decide. After a month, B promises to compensate A for the services rendered to him. It is a past consideration. Take another example. A has hired his friend B to provide tuition classes to his son, and A was in financial crisis, so he has promised that he'll pay B, but after 1 year or after when he'll gain a job. So this is what is the past consideration. उसकी job लगने के बाद में वो pay करेगा, पर services उसने पहले ही ले ली है. Next is present, or you can also call it executed consideration. When the consideration is given at the same time the promise is made. जब promise हुआ उसी time consideration दी. Means जब services provide करी उसी time in return consideration दे दी. Then it will be called as present consideration or executed consideration. The best example for such consideration would be a cash sale. When we buy something in consideration for money for a shop is a present consideration. आप दुकान पे गए, आपने दुकान वाले का मुझे शैम्पू देना, उसने शैम्पू दिया और आपने उसे in return amount of money जो भी required amount था उसका MRP था आपने वो pay कर दिया. So that is what? That is the present consideration. Next is future consideration. You can also call it executory consideration. Why executory? Because it will get executed in the future. when the consideration from one party to the other is to pass subsequently to the making of the contract. It is a future means it is yet to happen in future. D promised to deliver certain goods to P after a week. P promises to pay the price after the fortnight. जब P deliver होंगे उसके बाद fortnight पे वो price pay करेगा. Promise of D is supported by the promise of P. Consideration in this case is future or executory. Nextly, this was with regard to the kinds of consideration past, present and future. Next we have is privity of contract. So you can also call it as a doctrine of privity of contract. It's a general rule that only the parties to the contract can sue and be sued. Means only the parties can sue each other and can be sued. This rule is called privity of contract. This rule of privity of contract means that a relationship subsisting between two parties who have entered into a contractual obligation will remain between them. Even Lord Justice Denning had criticized this particular rule in a number of cases and observed that the privity principle has never been able to supplement another principle whose rules go much deeper. This following rule has two consequences. A person who is not a party to contract can't sue upon it even though the contract is for his benefit. चाहे उसके benefit के लिए contract क्यों नहीं बनाया गया, if he is not a party to the contract, he can't sue the other person for his enforcement. A contract can't even confer rights or impose obligation under it on any other person other than the parties. So even a contract's rights and obligation will be on its parties. No one else. Means the stranger to the contract is not allowed as such. So this was with regard to consideration as such and privity to contract. That's all for today's session. Thank you.